In this video, I, a practicing psychiatrist, will delve into the layers of evidence, the verdict, and the behavior of the hospital and legal teams involved to reflect on the realities of healthcare and justice as seen through the lens of a psychiatrist. I don't want to just examine the surface-level court decision. I want you to join me on exploring the profound implications of paediatric healthcare decisions, the critical overlap of psychiatry with medicine, and the often complex relationship between medical practice and legal accountability. Maya's story, while rooted in legal frameworks, highlights areas where psychiatry, medicine, and law intersect, sometimes harmoniously, often contentiously. Complex regional pain syndrome, or CRPS, is a rare chronic pain condition, typically affecting a limb after an injury. It's characterized by severe, prolonged pain that's disproportionate to the initial injury. The diagnosis of CRPS in Maya was the first step into a labyrinth of medical interventions. Given the elusive nature of CRPS, making the diagnosis itself and agreeing on the diagnosis across multiple healthcare providers posed significant challenges. And as the old saw says, when doctors differ, patients die. One key problem is that the condition's symptoms can vary widely, and there's no definitive test for CRPS, making it a diagnosis of exclusion. And diagnoses of exclusion are always very difficult and fraught with room for misinterpretation and disagreement in my clinical experience. The incidence of CRPS is estimated to be between 5 and 26 per 100,000 people, with a peak incidence at the age of 40, but with roughly 10% of cases being pediatric. Women are roughly 3 to 4 times more likely to be affected than men. There are two types of CRPS. CRPS-1, where there is no discernible nerve injury, and CRPS-2, where there is a confirmed nerve injury. CRPS-1 is 3 to 4 times more common than CRPS-2. In Maya's case, her diagnosis marked the beginning of a journey fraught with uncertainty and complexity. The pain, which began in one limb, expanded its reach, both physically and metaphorically, impacting every facet of her life. For her family, the diagnosis was a call to arms as they sought to navigate the medical system to find relief for their daughter. In advocating for her daughter, Beata Kowalski became viewed as difficult, intrusive, aggressive, and eventually troublesome, and potentially the real villain of the piece, a mother who was subjecting her daughter to harm in order to meet some obscure psychological need she had for attention. A mother guilty of medical child abuse driven by factitious disorder imposed on another, more commonly known as Munchausen by proxy. Let's define these terms, as I've seen a lot of misunderstanding about what they actually mean. Factitious disorder, imposed on another, FDIA. Factitious disorder, imposed on another, previously known as Munchausen syndrome by proxy, is a mental health condition where a caregiver or guardian fabricates or induces physical, psychological, or behavioral symptoms in someone else, typically a child or dependent, in order to gain attention or sympathy for themselves. The person with FDIA presents the individual under their care, often their child, to others, such as medical professionals, as ill or injured, even though the individual is not actually experiencing these health problems, or experiencing, but to a much milder degree. Medical child abuse, U.S. definition. In the United States, medical child abuse refers to a situation where a child receives unnecessary and harmful or potentially harmful medical care at the instigation of a caretaker. This abuse is identified not only by the direct harm caused by unnecessary medical procedures, but also by preventing the child from receiving appropriate medical treatment for genuine health issues. This is a crucial point, since it isn't just the unnecessary tests and treatments given which harm the child, but the necessary tests and treatments not given because of the spurious information being given to doctors that constitutes abuse. The treatment of CRPS, especially in children, is a delicate balance of pain management, physical therapy, and psychological support. In Maya's case, this balance was further complicated by the multiplicity of medications prescribed. The trial later scrutinized this aspect in great detail, but at this stage, Maya's parents and healthcare providers were primarily focused on alleviating her intense pain. The early treatment phase saw Maya prescribed a cocktail of medications, Each drug carried its own set of potential side effects and interactions, complicating her medical picture. Among these were potent pain relievers like oxycodone and tramadol, along with gabapentin and clonidine. Drugs typically used for neuropathic pain but not without their risks, especially in a developing child. If any of these drugs were unnecessarily prescribed because of false information provided by Beata, the presence of side effects could have justified an allegation of medical child abuse. So a lot of evidence in the trial looked at how routine and necessary these treatments were, and on what information they were prescribed. As Maya's parents grappled with her diagnosis and the complexities of her treatment, their role in her medical decision-making became crucial. If it was deemed that the parents were driving harmful treatments through false information, then Maya was their victim. But if the parents gave information in good faith, then even if the doctor's prescribing was unreasonable or harmful, they couldn't be labeled as abusers. I'm certain we'll find that which side of this divide the jurors came down on greatly influenced their verdicts at the end of the trial. In Maya's early treatment phase, her parents faced the daunting task of making informed decisions in a sea of medical uncertainty. The choices they made, and the actions of the healthcare professionals involved, laid the groundwork for the dramatic events that followed. It is important here to highlight that this is a damned if you do and damned if you don't scenario. How many of us have said we'd do anything for our kids, have ever wondered if doing everything for them would be viewed as tantamount to abusing them? This was the situation the Kowalskis found themselves in. Whether their decisions were right or not is not relevant to determining whether they were motivated by good intentions or FDIA, no matter how controversial those decisions are. Otherwise, you could end up with the specter of parents following medical advice, and if things go wrong, being labeled abusive because of the outcome as opposed to their intentions. We now turn to a critical and contentious aspect: the controversy around medications. This segment delves into the intricate web of pharmacological treatments prescribed to Maya, the challenges they presented, and the ensuing debate that became a cornerstone of the legal battle. Maya's treatment involved what is known in medical parlance as polypharmacy, the simultaneous use of multiple medications. This approach, while sometimes necessary, is fraught with risks, especially in pediatric patients. In Maya's case, the list of prescribed medications read like a pharmacological quiz for postgraduates: diazepam, clonazepam, oxycodone, tramadol, gabapentin, baclofen, ketamine, ketorolac, clonidine, and Tylenol. Each of these medications comes with its own set of side effects and potential interactions. The use of opioids like oxycodone and tramadol raised particular concerns about dependency and long-term impacts. The inclusion of gabapentin and clonidine, more commonly used for neuropathic pain and hypertension, respectively, added layers of complexity to her treatment, and the use of ketamine coma and at-home ketamine intake raised alarm among her treating doctors in Johns Hopkins. During the trial, expert testimonies shed light on the potential risks and inappropriateness of Maya's medication regimen. Dr. Wassenaar's insights, for instance, pointed to a possible oversight in prescribing practices for CRPS. The absence of SNRIs or tricyclic antidepressants, which are often used in CRPS treatment, was particularly noted. The testimonies raised critical questions about the standard of care in pediatric pain management and the ethical responsibilities of healthcare providers. The balancing act between alleviating a child's pain and avoiding overmedication became a central theme of the trial, highlighting the need for stringent guidelines and careful decision-making in pediatric pharmacotherapy. It is clear that the guidelines are no longer fit for purpose for edge cases like Maya Kowalski and need to be reworked and tightened as a matter of urgency in order to gain greater clarity on what is and isn't reasonable at the edges of the prescribing envelope. As Maya's parents navigated this complex treatment landscape and the difference in treatment advised by Dr. Kirkpatrick and others and their doctors in Johns Hopkins, their trust in her healthcare providers was put to the test. The dynamics between Maya's family and her medical team became increasingly strained, as concerns about overmedication and its long-term effects grew on one side, and anger at the hospital's perceived failure to adequately treat Maya's CRPS bubbled over on the other. The Kowalski family's growing apprehension and the subsequent legal actions underscore the importance of clear communication and mutual trust in the doctor-patient-parent relationship, particularly in cases involving long-term and multifaceted treatments. Whatever way you want to look at the interactions between the Kowalski family and Johns Hopkins, it is clear that trust and clarity of communication both broke down. As healthcare professionals and members of a large institution, it is more the responsibility of Johns Hopkins to maintain trust and clarity of communication than the Kowalskis. I admit that in my own practice I have come across some patients who are so difficult and not in contact with the reality of the situation that there's literally no possibility of having a reasonable conversation with them. But that's an exceedingly rare situation and something which I've only had occur on perhaps 2 or 3 occasions in the past decade. And I've seen thousands of patients over the last decade. It should not have been this difficult for Johns Hopkins to create trust and clear communication. The lawsuit against Johns Hopkins All Children's Hospital was anchored in several grave allegations: false imprisonment, battery, medical negligence, fraudulent billing, emotional distress, and wrongful death. Each of these charges brought to light different facets of Maya's treatment and the hospital's actions. The case was as complex as it was unprecedented. The allegation of false imprisonment centered on Maya's prolonged stay in the hospital under what her family claimed were unnecessary and restrictive conditions. The battery charge related to the unauthorized photography of Maya, a point that later became crucial in the jury's decision-making.
And she told me that if I wanted to go and see my mom in court, I was going to have to be stripped naked and photographed by her nude, so I could go to court. I cried.
The billing controversy centered around the hospital billing for treating CRPS, whilst proclaiming that Maya didn't suffer from it. This seemed contradictory to many. The wrongful death and emotional distress both centered around the death of Maya's mother and the role the hospital played in it.
In that note, what I focused on as to her state of mind, one of the last sentences, I no longer can take the pain being away from Maya and being treated like a criminal. I cannot watch Maya suffer in pain and keep getting worse while my hands are tied by the state of Florida and the judge. It's been 3 months today of Maya not being home. So that kind of shows what her state of mind is and the pain she was going through. My attention came to the very first sentence where it says, all children hospital in DC have destroyed Maya physically and mentally. She said, you let them continue to destroy her even more slowly each day. Maya will never be who she was before October 13th, 2016. And then she went on to say, by taking the side of All Children's Hospital in DCF, you have destroyed my family, my marriage. I hope that you will make sure that Dr. Malik at All Children's Hospital and Sally Smith will lose their medical license and never ever hurt another child again. That my family will be able to hug and kiss Maya soon, since you have denied me to execute my parental rights towards my child.
The Kowalski psychiatrist's testimony was also devastating in linking the hospital to Beata's self-termination.
48 to 72 hours, Beata had exhausted every defense mechanism she possibly could. And when human beings have exhausted their defense mechanisms and they have no alternatives, the mind begins to race and impulsive thoughts begin to enter. This is usually when we see people in our emergency room when they get that way, but usually it's after the attempts have happened and we find them in the intensive care unit. In my opinion, what happened in this case is the factors in the last 24 to 72 hours of Beata Kowalski's life were so overwhelming that her defense mechanisms allowed nothing other than an impulsive behavior.
And was a significant, if not major, the major part of this, learning the full extent of Kathy Beattie's treatment of her daughter?
It is my very strong medical opinion that the information that a parent would learn about their child is a significant factor for Beata Kowalski's.
Do you have an opinion based upon your background, training, and experience, and to a reasonable medical probability, as to whether Beata Kowalski's death was the result of an irresistible impulse to do that on that evening?
I do, and I believe that it was an irresistible impulse.
And then, do you believe that Beata Kowalski's perception of the hospital, particularly Ms. Beattie, others' treatment of her daughter, was a substantial factor in creating that irresistible impulse?
Absolutely, yes, I do.
And therefore, do you have an opinion based upon your background, training, and experience as to whether the hospital's treatment of Maya was a substantial factor in bringing about?
It is my professional opinion that the treatment of Maya Kowalski was a direct factor in the causative effects of Beata Kowalski's.
That's absolutely devastating testimony. Obviously, much depends on whether the jury believed the psychiatrist or not. But if they did, then this psychiatrist stating that the hospital's conduct had a causative impact on Beata's self-termination is a case-shattering. At the onset, the legal strategies employed by both sides were indicative of the case's contentious nature. The plaintiff's legal team, representing the Kowalski family, focused on painting a picture of medical overreach and negligence. They highlighted the emotional and physical toll of Maya's treatment, emphasizing the family's trust being betrayed. On the other side, the defense, representing the hospital, aimed to establish the necessity and appropriateness of their medical decisions. They argued that the hospital's actions were in line with medical standards and driven by concern for Maya's well-being, especially in the absence of clear treatment guidelines for CRPS in children, and that once they suspected FDIA, they were obliged to report it and obliged to treat Maya as they did. Those are two huge statements. Were they obliged to report a suspicion of FDIA? Yes. Were they obliged to treat Maya as restrictively as they did? No, clearly they were not. Yes, they were obliged to treat her to ensure her safety, but many of their restrictions seemed draconian, uncalled for, and difficult to justify. I know that were a psychiatrist in training to outline a treatment plan which mirrored what the hospital did to Maya, I'd consider it a very unempathetic plan, which was almost guaranteed to result in significant harm to Maya and her family, complaints and lawsuits against the hospital and doctor, and a sign of poor judgment on the trainee's part. There are many other choices one could make which are safe and reasonable, and not so punitive and destructive of the family's mental health. I'd be very interested to learn if Johns Hopkins had any psychologist or psychiatrist advising on the impact of their decisions on the mental health of the family and Maya. I would imagine they didn't, as I find it difficult to imagine any competent psychiatrist thinking this would be a good idea. The early days of the trial were emotionally charged. Testimonies from the Kowalski family members were particularly poignant, offering a window into the personal toll the ordeal took on them. The narrative of a family grappling with a complex medical condition and feeling let down by the system resonated strongly. These testimonies set the tone for the trial, framing the narrative around the human impact of medical decisions. The plaintiff's attorneys leveraged these emotional testimonies to bolster their case, aiming to sway the jury's empathy towards Maya and her family. It is important to note that multiple studies have shown that jurors are swayed by identification with litigants as well as emotional appeals. Indeed, a Texas Law Review study of 1,800 judges showed clearly that they were swayed by identification with litigants as well as emotions and sympathy for litigants, both in terms of verdict reached and amount of damages awarded. Bearing this in mind, it must be said that, in my opinion, the Kowalski's lawyer did a great job while Johns Hopkins' legal team conducted themselves in a bizarrely self-destructive manner. Around Halloween, the defense attorney Ethan Shapiro sought to introduce pictures of Maya out at Halloween and at homecoming, and used them to cast doubt on her previous testimony. I can see why he may have wanted to draw attention to this legally, but from a juror psychology point of view, it ran the risk of being seen as persecution of an already wronged teenager. I wouldn't be at all surprised if many of the jurors thought to themselves that if this was what the hospital was willing to sanction in a court of law in front of the world's camera, what on earth did they do when they thought none of this would ever come to light? Again, I just don't think the defense team either had any psychological advice on how to approach the case, or what advice they got was ignored or just plain wrong. Plus, it is an easy thing to refute, with the obvious reply being that it was a teenager who is suffering but determined to try to live as normal a life as possible no matter how difficult it is. An answer which would allow the jury to empathize and identify even more with the teenager, to the detriment of the defense's case. Let's look at Maya's response and see if she hit those points. I got my dress the day before homecoming, because I wasn't sure if I was going to be able to go. That was dependent on my physical condition and my mental condition. She also said that she cried from leg pain before the photos were taken, and that she only attended the event because the tickets had previously been purchased, and she felt obligated to go. Maya also acknowledged going out for Halloween, saying she spent a couple of hours at a friend's house at an event over the last weekend. Well, the defense just got murdered by words there. That's a tremendous own goal for the defense. The trial witnessed a parade of medical experts, each providing their insights into Maya's treatment and the standard of care in pediatric medicine. Particularly impactful were the testimonies concerning Maya's medication regimen. Experts like Dr. Wassenaar questioned the appropriateness of the prescribed drugs, particularly the absence of SNRIs or tricyclic antidepressants, which are often used in CRPS treatment. The testimonies raised crucial questions about pediatric pain management and the ethical responsibilities of healthcare providers. The balance between managing pain effectively and the risks of over-medication was scrutinized, highlighting a disconnect between Maya's treatment and established medical guidelines. Certainly her care wasn't standard or even common, but proving it be abusive as a result of misrepresentation by Beata is a very high standard of proof to reach. The Kowalski family testimony focused on their emotions. Their narratives provided a deeply personal account of their experiences and perceptions of the hospital's actions. Their testimonies underlined the emotional toll and the sense of betrayal they felt. On the other side, testimonies from hospital staff offered a glimpse into the internal decision-making processes and justifications for their actions. The defense aimed to portray these actions as being in the best interest of Maya, emphasizing the complexities involved in her care. One huge problem with this approach is that if you are relying on your standard of care to counter an emotional argument, then your standard of care and governance really does need to be exemplary, and Johns Hopkins wasn't. What's more, it was clear during the trial that the hospital had tried to avoid presenting evidence of its clinical and governance failures, something which, undoubtedly, looked to some like a cover-up. And juries tend to be very, very unforgiving of large organizations trying to hide important information from smaller litigants. The Johns Hopkins All Children's Hospital report reveals several deficiencies, particularly relating to failures in overall governance. Specific issues identified included infection control leadership responsibilities. The hospital failed to ensure that its hospital-wide quality assessment and performance improvement (QAPI) program identified infection control problems and reported specific findings on an ongoing basis to the Chief Executive Officer, CEO, and medical staff. Reassessment of discharge planning process. The hospital did not reassess its discharge planning process on an ongoing basis. The reassessment should have included a review of discharge plans to ensure they were responsive to discharge needs. This deficiency highlights a gap in the hospital's ability to evaluate and improve its discharge process continually. Surgical privileges. The hospital failed to delineate surgical privileges accurately for all practitioners performing surgery, as per the competences of each practitioner. This failure directly impacts patient safety and care quality, as it questions the adequacy of the process for granting and monitoring surgical privileges. Surgical equipment left inside patients. At All Children's Hospital, there were 2 cases where surgical objects were left inside patients and weren't reported to regulators, violating Florida law. In one case, the child's parents weren't informed. Unsterilized equipment used for surgery. Inspectors found that at Suburban Hospital, 2 patients were operated on with instruments that hadn't been sterilized, and neither the patients nor their primary physicians were informed. This is worrying not just because it happened, but also because there was a failure of transparency and communication. More generally, these and other failures pointed to failures in data-driven quality improvement. The hospital did not demonstrate an effective implementation of a data-driven quality improvement organization that measurably improved its ability to provide quality patient care and improve patient safety. Inadequate program data use and program activities. The hospital failed to use collected data effectively to identify opportunities for improvement and changes that would lead to better patient outcomes. It also did not set priorities for performance improvement activities that focused on high risk, high volume, or problem-prone areas, which affected health outcomes, patient safety, and quality of care. Failure to utilize collected data for improvement. There was a failure to ensure that collected data was used to identify opportunities for improvement. These improvements were supposed to be prioritized based on high risk, high volume, or problem-prone areas affecting health outcomes, patient safety, and quality of care. These deficiencies indicate systemic issues in the hospital's governance and management structures, particularly in how data is used to drive improvements in patient care and safety. They also demonstrate a significant failure to comply with Florida law regarding admitting medical accidents and also in informing parents of these incidents. I can only imagine everyone on the jury considered whether the behavior in this independent report also occurred during care of Maya, and trusting anything and everything else the defense lawyer said just that little bit less going forward. I've sat on governance boards in hospitals, and I've got to say that this conduct strikes me as real amateur hour stuff at best, and maliciously incompetent at the other. It is difficult to imagine how such a large organization could be doing the basics wrong so comprehensively over such a long time. The use of medical experts in court systems varies between the United States and the United Kingdom. In the US, each party typically hires its own medical expert. These experts are often chosen for their specific expertise in the relevant area and their ability to effectively communicate complex medical issues to a lay audience, such as the jury or judge. The adversarial nature of the US legal system means that experts can be viewed as advocates for the side that hires them. In the UK and similar systems, it's more common for an independent expert to be appointed by the court. This expert is expected to be impartial and to serve the court rather than the parties involved in the case. Their primary duty is to the court, providing an unbiased opinion based on the evidence. I've been a medical expert on numerous cases, and I've always been taught and viewed it that my role is to be an unbiased medical expert, to help the court understand the medical issues, not to advocate for one side or the other. In both the US and UK systems, medical experts can be cross-examined, sometimes aggressively so, but again, in the UK system, because the expert is viewed as an independent, unbiased provider of information, and understanding it rarely gets as aggressive as I've seen in US courts, where experts are often viewed, and often carry themselves as hired guns for the opposing side. The jury was given 80 pages of instructions from Judge Hunter Carroll, and had to decide on 7 claims. After an intense and emotionally charged trial, the jury delivered their verdicts, finding Johns Hopkins All Children's Hospital liable on all 7 charges: false imprisonment, battery, medical negligence, fraudulent billing, emotional distress claims including wrongful death, and Maya's personal claim for infliction of emotional distress. The total award to the Kowalski family exceeded $261,451,174, including $50 million in punitive damages, a sum reflective of the jury's stance on the gravity of the hospital's actions. Each verdict addressed a different aspect of the case, collectively painting a picture of a series of missteps and ethical breaches. The charges of false imprisonment and battery were particularly notable, stemming from the hospital's handling of Maya's care and the unauthorized photography, which the jury found to be invasive and unethical. The verdicts have profound implications for pediatric health care. They highlight the need for stringent adherence to ethical practices, the importance of clear communication with families, and the necessity of maintaining patient autonomy, even in complex medical scenarios. The verdicts underscore the potential legal ramifications of medical decisions and the importance of ensuring that treatment plans align with established medical standards and ethical guidelines. In both public and private healthcare systems, life is not incalculably precious. Many public health systems use the concept of the quality-adjusted life year, to calculate a cost they will pay to keep someone alive for another year of perfect health. In much of Europe, that hovers between 15,000 and 25,000 euro, meaning that in a country with a quality of 20,000, they'd pay 10,000 for a drug that kept you alive for another year, with a 50% improvement in health. If the drug costs 20,000 for that same 50% improvement, then the health service wouldn't pay for it. Limited resources don't support unlimited wants. I'm reminded of the infamous corporate ethics case revolving around Ford Pintos in the 1970s. In the case of the Ford Pinto, it was discovered that the car's fuel tank was prone to rupturing in rear-end collisions, potentially leading to deadly fires. An internal cost-benefit analysis known as the Pinto Memo was reportedly conducted by Ford. This analysis compared the cost of reinforcing the fuel tanks at $11 per car, $137 million for all cars, against the potential costs of settling lawsuits resulting from possible accidents, estimated at $49.5 million and 180 deaths and 180 serious burnings. The analysis suggested that it would be cheaper for Ford to pay off possible lawsuits for injuries and deaths than to make the safety improvements to the Pinto. So, Ford's management decided to let the people die and suffer to preserve profits. It seems to me that private healthcare systems don't have anything like the quality. Instead, they have the fear of being sued, and that in an appeal to their ethics and better natures, or to their profits and bonuses for performance, you're always better off appealing to their profits and appetite for performance bonuses. So I think the $261 million verdict, whether or not it is reduced on appeal, is the best motivator possible for a for-profit healthcare system to change. Don't ever make the mistake that at the management level these healthcare systems care about you. They don't. They care about profits and whatever makes the management looks good, not about your personal experience or outcome. Big lawsuits and verdicts against them endanger those two items, and so, in my opinion, promote positive change, which otherwise wouldn't happen. Cynical? Yes, but it doesn't mean I'm wrong. I once heard about a discussion in which the prospect of potentially saving half of all people with cardiac arrests by ensuring specific equipment was available was discussed. Only half of the doctors knew how to use that equipment, the other half would have to be trained up. The hospital safety manager objected to the new equipment on the basis that it would introduce inequality of outcome and leave the hospital open to being sued by the families of the half of patients who died when a doctor who hadn't been trained was on duty. In the end, they decided not to introduce the new equipment, ensuring a far lower chance of saving anyone at all in order to avoid an illusory legal risk. This is the sort of mindset good doctors and nurses are facing every day behind closed doors in innumerable boring meetings with clueless and uncaring managers.
1. Did Johns Hopkins All Children's Hospital falsely imprison Maya Kowalski without legal authority under circumstances that were unreasonable and unwarranted between October 7th and October 13th, 2016? Yes. 2. What is the total amount of Maya Kowalski's damages for the medical and psychological expenses to be incurred in the future after she reaches the age of 18 based on the false imprisonment occurring between October 7th and October 13th, 2016? $2,496,000. 3. What is the total amount of Maya Kowalski's damages for pain and suffering, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future, based on the false imprisonment occurring between October 7th and October 13th, 2016? $3 million.
The conclusion of the trial marked the beginning of a new chapter in the Maya Kowalski saga. The jury's verdicts, while bringing legal closure, opened up broader discussions about the implications for pediatric healthcare, legal ethics, and the role of media in narrating complex medical legal cases. The public reaction to the verdicts was multifaceted. While some hailed it as a landmark victory for patient rights and healthcare accountability, others expressed concerns about its potential impacts on medical practice, fearing an increase in defensive medicine or hesitancy in treating complex cases. The substantial media coverage further amplified these debates, bringing them to a wider audience. I have seen it suggested online that this verdict will prevent doctors and nurses from reporting suspected child abuse. I disagree with this view. The hospital wasn't found in the wrong for reporting their suspicions, and this verdict wouldn't cause me a second's hesitation in reporting suspected abuse. It would give me great pause about working in a hospital with clearly deficient information, communication, reporting, and governance structures, though. The release of the Netflix documentary Take Care of Maya added another dimension to the case's public perception. The documentary, while shedding light on Maya's story, has been criticized for presenting a somewhat one-sided narrative, potentially oversimplifying the complexities and ethical nuances of the case. I reacted to the documentary previously, there's a link to that above now, and at the time wondered if what we were seeing was a one-sided view of what happened. After seeing the evidence at trial, it is evident that the documentary was highly selective in what it presented, and gave a very incomplete picture of what happened. At times a quite misleading one, in my opinion. With that said, the central allegation of the hospital's behavior was proven true, and we must not lose sight of that. The documentary's portrayal sparked discussions about the responsibilities of filmmakers in presenting balanced views, especially in cases involving medical and legal matters. While it succeeded in bringing attention to Maya's plight, it also raised questions about the portrayal of healthcare professionals and the potential for media to influence public opinion in ongoing legal cases. From a purely medical point of view, I believe there are a number of lessons learned. Firstly, governance failures at Johns Hopkins, All Children's Hospital. There were lapses in ethical decision-making, patient autonomy and rights. The trial highlighted significant lapses in respecting patient autonomy and rights, particularly in Maya's case. The false imprisonment and battery charges point to a failure in upholding ethical standards in patient care. Informed consent. There were evident shortcomings in obtaining proper informed consent, especially regarding Maya's treatment and the unauthorized photography, indicating a breach in fundamental patient-caregiver trust. There were oversight and internal policy shortcomings. Medical treatment protocols. The medical negligence findings suggest that the hospital's treatment protocols, particularly for complex cases like CRPS, were either inadequate or not properly followed. Pharmacological management. The over-medication allegations and the prescription of an extensive array of medications without evident standard protocols reflect poorly on the hospital's pharmacological oversight. There were administrative and organizational gaps. Communication breakdowns. The trial exposed significant communication breakdowns between the hospital staff, the medical team, and Maya's family, leading to a lack of coherence in her treatment plan and decision-making. Responsiveness to patient needs. The hospital's responsiveness to the evolving needs and conditions of Maya was brought into question, suggesting a disconnect between patient care objectives and actual practices. Significant accountability and transparency issues. Handling of complex cases. The way the hospital handled Maya's complex medical situation raised questions about accountability and transparency in dealing with critical patient care issues. Public reporting and disclosure. The case also sheds light on the need for better public reporting and disclosure mechanisms in healthcare institutions, particularly regarding patient outcomes and treatment approaches, as well as more stringent consequences when this doesn't occur. The hospital's reaction to external scrutiny was, at the least, not transparent, and, at most, dysfunctional. Response to legal challenges. The hospital's legal and public relations strategies during the trial indicated a defensive stance rather than a transparent and accountable approach to addressing the allegations. Let's hear from Maya now and listen to her comments on the court steps.
For the first time, I feel like I got justice, and to a lot of people, that's unfortunately not something they could feel in this situation, and I'm just blessed that I could feel that for myself, for others, and for my mother. I have her engagement band on my ring finger. I have her rosary. I have this, there's a lot. I have this necklace, which I actually gifted to her from Johns Hopkins Children's Hospital, and I added one pendant, which is a picture of my mom and I in Monterrey, Mexico, around the time I got my gun income.
Parents have rights, and they make the decision.
So in conclusion, I think that this case is going to frighten a lot of poorly performing hospitals into being far more invested in good communication, adherence to standards, and getting timely advice about what they are required and allowed to do by law versus what someone on their staff thinks is right. I also hope it would cause hospitals which don't already have protocols about invasive investigations to create those protocols in order to prevent situations like the inappropriate photographing of Maya occurring. I also hope that once the next court case concludes, the Kowalski family will be able to move on from this and build lives they enjoy. They'll never forget Beata, but it is important for them all to eventually look forward and create the life she would have wanted them all to have. If you found this interesting, please consider hitting the like and subscribe button to be notified when I release my next video.